My call signs, Chief of the Ram.
Hey everybody, welcome to this week's YouTube Live. You are lucky you have Mr. Carey Baker and me here today to help you. I've got lots of coffee and we are ready to jump into it. You ready, Carey?
I am ready.
All right, Benji, let's get this show on the road. I'll go first. Okay. Angel Marrero, greetings HMP. VA has ordered a second CMP this time, an ACE exam, stating to determine my current level of disability. Is this good news? Thank you. Yeah, I mean, anytime you get scheduled for an exam, it's definitely not bad news. It means that VA is taking your claim seriously, and they're either needing to find out the severity of your condition or get medical opinions on whether or not it's service connectable. If they've got another one and it's an ACE exam, so an ACE exam is an exam that does not require you to attend, which means that they're going to send your file to a doctor. The doctor is going to do a medical review and then come up with their own determination. This is usually done when either the CMP came back and it wasn't good enough for rating purposes, or it was inconsistent, or the rater needs additional things quantified or figured out because of that CMP. So that's most likely what that means. Whether or not you'll get a favorable decision, I don't know, but it means that whoever's looking at your claim isn't just looking at the CMP and making a decision on it. They're actually taking the time to review it. Carey?
I got nothing. I agree with what you said.
All right.
Step by step, one of several. All right, that's concerning a little bit there, Mr. Step.
Like or Miss, three. We don't know. Could be Miss.
Could be two. Could be three. Update on caregiver appeal. BVA granted on 1/7/25, retroactively putting us back in the program to September 2018. We didn't hear anything for months. Tried contacting VA RO, caregiver, coordinator, supervisors, and finally reached out to our representative. What was interesting is initially the VA called us and said they could do anything and that they didn't know anything new. I'm guessing you mean they could not do anything. After a week or two, we got a call from the VA liaison who deals with congressional, and we're told it would be completed in 7 to 14 days. As of today, we are back in the program level 2 and awaiting back payment and notices from VA about the implementation and payment breakdown. This comes at a good time as we just submitted a supplemental claim for SMC-T, which we've been fighting since 2019. Thank you for all that you do. All right, so I'm not sure there was a question there. But that's an interesting topic for us because we are just getting to the point where we are seeing board decisions on caregiver appeals. It wasn't that long ago that the court said that, yes, caregiver is a subject that can be appealed because VA originally said it could not be. So, and these are all done at the VA medical centers, not the regional offices, not the normal claims folks. So like in our cases, we log into a program called VBMS, which is what VA uses, and we get access to it. We don't see anything about the caregiver stuff because it's done at the medical center. So it leaves a gap for us. And I'm sure for you guys too out there doing it, if you're doing it on your own, And so there's some unknowns for us in this. For example, your back pay. How does it come? When does it come? Who pays it exactly? How do you confirm it's done right? We don't have, to our knowledge, all right, because this is all still so new, we don't have visibility on that unless it's done through the normal system, BBMS, and their normal payment system, which I doubt that's how it's going to be done since the medical centers are implementing this. There's notice issues. We don't always get notified of what the caregiver program is doing with our clients like we would in a normal claim. Now, if it's a board decision, they're going to send us a copy. So there's a number of unknowns. And so we're interested in this subject. I think there's a lot to learn on everyone's side, but there's also a lot of gaps that VA hasn't filled yet that they need to fill, both for us and for you guys. They need to start notifying us of everything. They need to give us access to the records that they use so that we can see what they're using, so that we can do our job and represent you. Good story. I'm glad you shared that. I'm glad it's working out for you. Got any other stories? Feel free to let us hear them.
All right. Chris A. One of, I'm not too sure how many. Got another one. Let's do it. I found what I think are 2 pending claims back to 2012. Under Barad v. McDonald, VA must respond to directly with a new submission of evidence received prior to the expiration of the 1-year appeal period. VA decided mental health in September of 2012 and got a CEST EP 930 to reopen claim for quality error awaiting for SSDI record. November, VA decided migraines, and in December, they received SSDI. First, am I incorrect that these are pending? Second, I filed for these under Q before I found this. The Qs are pending under higher level review. How do I force VA to treat these? As pending claims since 2012, actually back to 2009 since I first filed, and 2012 was the VA appeal. VA issued no decisions on these after 2012. I did submit a new statement in support of claim outlining the new legal theory and new evidence. So far, VA is turning a blind eye. Okay, so what you're essentially talking about and what that case talked about is back in the legacy program, if you had a claim that was decided and within 1 year or within that appeal period, new and relevant evidence entered the file or a statement or something, that VA was supposed to re-adjudicate that claim. If those Social Security disability records had in part information about your mental health claim that had been denied, then yes, I think that would still be pending, and VA would have to go and reopen the claim to take a look at it. Now that means that claim would still be pending. However, if after the submission of those Social Security documents, you filed a claim, let's say in 2020 for mental health, and it was denied, then that claim is no longer pending. So it all depends. Like if you filed it, you were denied, new evidence enters the record within 1 year, they never adjudicate that, and then you're back to the effective date of when that new and relevant evidence came in. It wouldn't necessarily, and this is where Q and pending claims kind of get a little muddy, because you wouldn't assert a Q to that a decision that denied it. And the reason you wouldn't is because at that time, those records were not before the rater. They didn't have it. So when they made that rating decision, they didn't have them. So there's no Q in that decision that denied. The issue is that there's still a pending claim. And like I said, it all depends on whether or not later claims subsume that earlier claim. But if it goes, you were denied within 1 year, there's evidence that they should have readjudicated, you file, you get granted, then your issue is you're appealing the effective date of that grant. If it is still open, if that claim is still open, you can do an earlier effective date and ask them to take it back because that claim is still pending. But if that claim, you've got your rating decision, new evidence, you get granted in 2020, and that claim stream closed, and they give you a effective date of 2020, and there was no appeal to that rating decision, you may be able to assert a Q to that for the effective date because the claim was still pending and they didn't give you the earlier effective date. So it can get kind of complicated. I hope I answered your question, but it depends on the procedural history on whether or not you'd want to do a Q or argue a pending claim, and you're probably going to have to take it to the board. Gary?
I really don't think I have anything else to add to that. I tried to follow the question. I got a little confused with it. I think you did a great job answering it. I'd have to go back and read it again because I'm guessing if I got a little confused, VA is probably getting a little confused. But yeah, I agree with you. The Q, you got to think by Q, it has to be based on the record at the time and the law at the time. So if there's an element of new evidence that they didn't have when they made that decision, it can't be Q. And anytime something is pending that you can attack directly, like you get a decision, you disagree with it, you appeal it, don't raise Q because you're raising your legal bar way above the standard for winning that claim. Just appeal it and fight it on the merits, on the actual facts and the law. Q is reserved for when something is way outside the appellate period already. The Q is the only way to get at it. Now, that may be the situation here. I couldn't follow all that. But if it's subject to direct appeal, don't do a Q. But it sounds like that's it's already in the mixed. So
I would pull the Q. I don't, if you file, if this is the first time filing in 13 years and you're filing to reopen that mental health claim, my suggestion to you is just for right now, do not worry about that effective date of 2012. Get the service connection in the first instance. Get that service connection. Once you have that service connection, then go back and say, hey, my effective date is incorrect, and this is why. I filed new and relevant evidence entered, and my effective date should be when I first filed. That's going to be the least messy way to do it, I think. But everybody might do it differently.
And I'm just thinking out loud here. You may be getting the deer in the headlights reaction from VA. Sounds like there's a lot going on here. You may need some professional review of the case if that hasn't been done, just to make sure that things are going the way they're supposed to go in the right direction. There's a lot going on there that I could see VA just quietly ignoring. We see them do that a lot. It's usually not technically on purpose. It's more of ignorance, but it's hard to say.
All right.
HL. I was denied migraine and headache secondary to VA disability, PTSD, tinnitus, asthma, and sleep apnea. What should I do next? This was a supplemental claim with new evidence. Well, you got to look at your options and figure out which one works best for you. One, why was it denied? Guess is if they did their job the way they're supposed to, they should have gotten a VA exam with a VA medical opinion. If they denied it based on a bad VA medical opinion, Um, on a negative VA medical opinion, if there's anything wrong with it. Probably, because there's something wrong with most of their negative medical opinions. Find out what that is. You can attack that with a higher level review, or if you have additional evidence to come back and fight the claim, you can do another supplemental claim, or you can appeal it to the board. If you appeal it to the board, you can go through their evidence lane. If there's new evidence, the direct review lane or a hearing lane. So when I say you got to figure your options out, you really do. I think there's a total of about 5. And one may be just as good as the other in certain circumstances, and it might be a coin toss. Other times, you really need to go specific directions. But without knowing exactly why, I would be guessing. But if they did it right, I'd say it was a bad medical opinion. And they could have just not gotten one. If they didn't get a medical opinion, then I'd go HLR and say, look, I filed a valid claim here secondary to all these things, and they didn't develop the case by getting a medical opinion. HLR will most likely send that back and tell them to get a medical opinion. But if they got one, got to find it, got to look at it, see what's wrong with it. There probably is something. Anything, Ursula?
No, without knowing like why they denied it and what the medical opinion said, it's hard to give guidance on what to do. Benjamin Sand, is it considered poking the bear if I file a claim for extra educational benefits? I already exhausted my GI Bill and post 9/11. I only served 1 term, but I was extended past my 4-year enlistment. Against my will to finish my 3rd deployment due to 9/11. Does this qualify me for the Rudisill decision? I don't know anything about the education benefits, to be honest with you. It's not an area of law that I practice, or I know that they're available, but I don't do anything. So I don't have any input on that question. Carrie, do you?
Maybe. Okay, so for one, I'm not familiar with the Rudisill decision. Now I kind of want to be, but putting the Rudisill decision aside, unless it does something in the education world that I'm not familiar with, and it very well might. I haven't been in education side of the house in a number of years, but I can tell you this much: unless that Rudisill decision does something to extend things or to expand things, it has always been that once you run out of educational benefits, all right, well, regardless of what kind it is, there is no expansion of more educational benefits. Now, I don't know, like I said, if that decision changes that, but that's if you have entitlement to, say, a couple of different forms of education benefits. Have you maxed out all of them? And if the answer is yes, I just don't know anything that does extend that unless that decision does. So if that's the case, you probably got nothing to lose by asking VA, because there could be something I'm not aware of.
All right. So I just read it and I do remember hearing about this. It essentially says that if you've had multiple enlistments, you can use the benefits in any order. So yeah, I don't know. So sorry.
You stumped
It is
us.
about benefits. Yep, you did. You did. All right, that's you.
Agent 2017. Why not 2018? So, hello. How does one send you some information, not a claim request, but something maybe for your review and response in this forum, please? It's in response to a pre-filing consultation and the proposed HB, I'm guessing House bill, maybe,
Yeah.
giving non-accredited organizations assistance to veterans. Yeah, I'm not sure that you want to send that in this forum. it depends. You know, you can send, if you have any of Helen Potton's emails, you can send something, for our review. If you're just asking our opinion on it, but I need a little bit more information than that. When it comes to pre-filing consultations, I don't know if you're asking from the position of a representative or the position of a veteran going to one of those forms of representatives. So I don't know. I'm not, to be honest, I'm not a fan of the non-accredited organizations. Pre-filing consultation, if you're referring to one that you have to pay out of your pocket for, because I know there are some out there like that, not a fan. I don't think that's ethical. If for people that make veterans do that, it's not necessary. But again, I don't know if you're asking from the business side of the house or the veteran side of the house on that. I would just need a little bit more info. But there are general email. Do we have a general email? Ursula, do you know?
You can probably find it on the website. Yeah. So I'm looking up, I know NOVA, which is the National Organization of Veterans Advocates, which we're all members of. They are working really closely with other bills that are out there. So there's more than one bill floating, and some are better than the other. So until something kind of gets passed, I wouldn't worry too much. I know that for us and for NOVA, we're trying to make it so that non-accredited people can't do these types of things. The non-accredited agents and companies that charge for filing initial claims, or they charge up front for things, I think can sometimes be predatory. And we're working really hard to make that not happen, so that only accredited people, whether it be agents or attorneys, are able to represent veterans. And because we have a lot of rules that we have to follow, we're bound by the rules of the bar, and we're bound by the rules of VA, and non-accredited people are not bound by those same rules. So they can do all kinds of things. So, you could probably just go to our website if you don't have someone's email address. And I think there's an intake thing there. Just say, on the live, I wanted to send this in, and we can look at it. But I was trying to find the House bill that we're going after, so that you guys could go talk to your representatives.
I think our host put something up as well for the person.
I can find it and let you guys know what the House bill is, so you can talk to your representatives and make sure that this is the one that goes through, that only allows accredited people to do things. So that's it. Sorry. I'll find it. And then Baker, was this my turn? Yeah. What can we do as veterans to get VA to honor VHA Directive 1134, amended 2020? This policy states that all forms will be completed by providers and specialists. There's a YouTube video of Shulkin stating that he will make sure it will happen. Thanks for all that you do. So I'm not entirely sure what the VHA directive is. I
think
what it has. Yeah. Okay, then you take this one. I'm going to keep looking for that House bill.
All right. If it's the directive, I believe it is, and I don't have the numbers memorized. It's the one that gives VA physicians the authority to, for example, help you fill out forms, help get a medical opinion to support your case, that type of thing. This issue, whether VA, experts, be it a physician, nurse practitioner, whatever your your care provider might be, whether they're allowed to do that, whether they should do that. The issue's been floating around for 20 years, if not more. And the problem that you have is you have hundreds of fiefdoms out there, and I don't mean that literally, but each medical center, all right, has its own administrator and administration and bosses that tell their physicians and care providers what they can do, what they can't do. And not all those people at the level that you meet are going to be familiar with all those directives. Not at all. So they don't go to law school or medical school to learn all that stuff. And they are told in lots of situations by their local folks that no, you're not allowed to do this, when the directive says no, they are allowed to do it. Now, I don't know what the 2020 up change is to that directive, but I know prior to 2020, the directive did tell treating physicians that they are allowed to do it, but they're not mandated to do it, especially if they feel they don't qualify to offer that type of assistance. And it's usually a medical opinion. I mean, the examining physicians usually aren't sitting there filling out a form. So it's usually we're talking about a medical opinion to assist in the completion of the claim. They are absolutely allowed to do it. How you get them to enforce that, that's going to be a local thing at that particular facility. One, they've got to know about the directive. All right. If the physician tells you they're not allowed to, have the directive in hand, because it clearly tells them they are allowed to. At least force the physician to acknowledge what the rule is and come up with a reason that they won't or can't. Because if they just say no, I'm not allowed to, well, that's just not true. They may still come back and say I'm not qualified to. That's going to be a case by case situation at that point. And if they insist that they're not allowed to, and that their bosses tell them they're not allowed to, squeaky wheel gets the grease. You have to go up the chain at the local facility. You might need to raise a little, with it. But it can be done, I'm sure. Go to the patient advocate, go up from there, even to the director's office if you have to. But good luck with it. It's for those places that refuse to do it. It can be like pulling teeth. That's all I got.
All right. I can't find that House bill, so I'm going to stop looking so I can pay attention. But I'll find it. All right. Yolanda Rouge Adams, 1 of 3. If you have loss of use of foot, leg, and an organ, FSAD, is it a single SMC-K? And if I have PTSD 100, HES plan is 50, sleep apnea 50, migraines 30, rhinitis 30, pancreatitis 30, TMJ 30, left hip 10, right hip 10, right knee 10, with other issues pending, back, sciatica, bilateral feet. Am I eligible for SMC-S and K? Does it have to be a single condition? Oops, that was me, sorry. At 60%, or can it be combined at 60? Okay, let's go back to the start. Sorry, I see you over there. You want to do it. You want to take it?
Yeah, I can take it. I mean, basically, if everything there is on your rating, loss of use of foot, leg, let's just say it's the same leg. Doesn't matter if it's foot or leg, it's just one. Loss of use of a creative organ, if they've granted that, and then 100% plus all those other things. All right, you don't need all those other things. You just need a couple of them that come to 60. You're looking at SMC-S and 2 Ks. So the question, if you can get more than 1 K, yes, you can get more than 1 K. You can get multiple Ks. In this case, from what I can see, you're looking at SMC-S with 2 Ks. And that's it. Now, depending how severe your PTSD is, and you've got a few things at 50% and the migraines, I would ask, somebody else have to help you with the activities of daily living. You got a pretty high rating there. Maybe not. Don't push it. If you can get up, dress yourself, feed yourself, make your own food, keep yourself free of harm, I'd leave it where it's at. But yeah, that should be SMCS in 2 cases.
That was a way shorter answer than I would have given. So thank
Hey,
you.
you got anything better to deliver, please do so, because mine was kind of short.
Yeah. All right. So Lonnie Brinson, BVA motion to advance on the docket with serious illness. Will the board consider loss of use of both feet, SMC-L with bowel 100 and bladder 60 incontinence, a severe case of illness to advance it forward? Is that the only, okay, so it ends right there. So it has to be, it doesn't have to be, but we've seen mostly in terminal cases that they're going to advance on the docket for terminal illnesses, meaning you are at the end of life, you're terminal, your condition's not going to get better. They do grant sometimes on this, sometimes they don't. I have never actually figured out in what cases they do grant and they don't grant. I think it's worth a shot to put it in there, get your evidence in, you know, that you're having a hard time. If you just put in an advancement with no evidence to support it, it's going to get denied. You have to put something with it. So I mean, I'm sorry. I wish I could tell you that, yeah, that's a surefire advancement on the docket, but just.
Now, if your question is, will they look at all of that and advance it on their own? And I don't know if that's what you're asking or not. They will not. Okay, unless you're 75 years old or older, they will not do it on even you can be terminal if they don't know it, and they won't until they start looking at the case, which is already too late. Right? You have to do the motion and ask them to advance it for whatever the cause is that you want them to. They won't do it on their own unless it's age. All right, Dave Armstrong, 107. Don't we have a limit to 5 for 4? Is it 3?
Just go through it.
Okay.
Just go through it. We'll try to keep up. It just gets very difficult to keep up with things.
I was joking. Sorry, Dan and Ursula. I'll be as brief as possible. I served on a Navy ship within blue water boundaries continuously from 11/30/70 to 1/3/71. I was diagnosed with ischemic heart disease in 2006, culminating with a heart attack, a triple bypass in 2019. Received a defibrillator implant in 2022 due to being at risk for sudden cardiac death. Diagnosed with advanced prostate cancer in 2016, underwent prostatectomy and radiation treatment. Active cancer cells remained, and I'm now required to receive hormone therapy. Treatments for life to prevent cancer from metastasizing. I filed claims for both conditions in April 16, 2025. I submitted all medical evidence, 19 years for heart, 9 years for cancer. Submitted backlogs, show ship positions in and around the mouth of the Mekong River, usually within 3 miles during the day, along with my entire military service record. Claim status is as follows. Radiation, tell us how you were exposed. Needed by you, August 6, 2025. I'm confused. I never claimed exposure. Should I submit a personal statement stating I wasn't exposed and my claim is AO presumptive? Yes, you absolutely should. They clearly took radiation from something that you submitted, and you know, or they just completely screwed up. But if you are not claiming any radiation exposure, and you don't need to from what I just read, then I would send them a letter and be very specific. The one that you did not claim that your conditions are related to radiation, to any extent that they interpreted that those conditions are related to radiation, you are withdrawing the radiation portion of the claim and clarifying that it is a herbicide related claim for presumptive service connection for heart disease and prostate cancer due to exposure to Agent Orange. I'd make it brief, keep it about half a page, and send that into VA and tell them to cancel any radiation development that they are currently undergoing. If you just got that letter, now's a good time to respond to them on that, because you do not want them going down the radiation road and sending your file to Jackson, Mississippi, if they haven't already. They might have, because it takes forever and is a nightmare, and it will not help your case. It will just delay the crap out of it. And it sounds like you have an extremely solid case there, and it should come out completely in your favor. Anything, Ursula?
Nope, that was good. Alan, if I'm service connected at 0% for hemorrhoids under the old guideline, should I now be rated at 10%? What is the next step if your higher level review is denied? So I'll be very honest. I would have to look up that rating criteria. Carrie, can you look that up? Or I'll look it up. I don't know.
Well, if the question is, does it get rated higher just because of the rating schedule change? The answer is they're not going to do that automatically. It sounds like you have a claim in for it, but maybe I misheard the question.
So VA has to, when you file a claim, if you're rated under an old schedule that is more favorable than a new rating schedule that comes out, VA has to keep you at the old schedule because it's more favorable. If the new rating schedule is more favorable to you,
I don't know if you can hear me, Ursula, but you are frozen.
I'm back.
You're back.
I'm back.
I was about to throw you a lifeline, but you were gone.
All right. So I don't know where I left off, Carrie. What was the last thing I said?
You were kind of early in that. You were out for a good few seconds.
All right.
There.
So I'll just kind of start over. So the general rule is if there's a rating schedule change, if you are rated under one rating schedule and then it changes, VA is supposed to rate you under the more favorable rating criteria for you. That goes for any conditions. If you have a condition, they change the rating schedule and you want to get a higher rating because the new schedule is more favorable to you, you would have to file a claim for that. They're not just going to go into your file and do that. You just want to do like an increased rating. So that's just generally how it is. No matter whether it's the old schedule or the new schedule that's more favorable, they have to rate you under that schedule. But the next steps after a higher level review is denied, you've got a couple of options. You can go back into the supplemental claim lane with new and relevant evidence. You can go to the board into any of the three lanes that are there. So if you want to go to the board with evidence, you can do that. So those are really your options. What you can't do is go to another higher level review. That is the only thing you can't do. But you've got lots of options just depending on your situation.
Perfect. Shimp Howard. Good afternoon. How you doing? Finally got my C-file code sheet. My recent conditions indicate static, and under RFE indicates none. RFE is request for future exam. I presume I'm safe unless I file a new claim. That you are generally presuming correctly. You should be safe unless you file a new claim. That means in their system they have no flags to schedule you for a future exam unless you give them a reason to.
But that doesn't mean they won't. Just saying. You never know.
They probably
VA.
won't. Yeah.
They probably won't, and you're
Probably won't.
mostly safe. But if 5 years from now you get called in for a CMP, like you do have to go. But yes, you're generally safe. Sharon Johnson, Howard. Yeah. I read the VA was changing its criteria for sleep apnea, eliminating 30% rating and no automatic 50% rating with CPAP. It was supposed to go into effect in April of 2025. Has this happened? This has not yet happened. It's been supposed to be going into effect for a while.
Like 2 years. Yeah, like two
Yeah.
2.5 years.
Yeah, so they do proposals all the time for ratings and all of that, and it takes them a long time to get it in, but no, it has not yet gone into effect. And keep in mind that, if while you're, in the pendency of your claims, that law does change, this goes back into what I was talking about, the rating schedule. They have to use the one that's most favorable to you. So
yeah, and it was never supposed to have gone into effect April 2025. I don't know where you heard that. We simply don't know. Anybody that tells you they do know better have a direct line with VA central office and the secretary's office, because otherwise they don't know either. Simply because of the regulatory process. It's got a bunch of hurdles to go through, and VA's a little busy at the moment, and so we don't know when it's going to happen. It does eliminate the 30 and the 50. In fact, you're going to be limited to 10% if you don't have a claim pending already. So
get them in.
Brian Snyder, if my new MS-DBQ has the boxes checked for assistance needed with bathing, med management, and preparing meals, is that enough that the rater should grant SMC-L aid in attendance, and would they grant it automatically? If they're doing their job right, yes. If they do not grant it automatically, in that case, I would ask for an HLR, and I would point that out to the HLR that your examiner expressly said you needed help with bathing and management and preparing meals. Preparing meals, that's not going to get you where you want to go. Help eating would, okay? Medication management by itself, not going to get you where you want to go either. Not sure really why those are on there. But help with bathing, even if that's all the help you need, that is enough for ANA, which is SMC-L. So,
yep,
that's that. So I have a gnat flying around me, so I'm not like having a fit. If you see me fly, I'm sure the camera can't see it.
We cannot. You just look like you're
I might be having a fit. I mean, but I'm also having a gnat problem. Having a fit at the net. Never mind. Go ahead.
All right. I've been diagnosed with sleep apnea. It was prescribed an oral appliance by mask interferes with PTSD. Do I have to use the device in order to be compensated for sleep apnea? No, you do not. You need to be prescribed the device. Not a lot of people can't use it for that reason, but the sleep apnea needs to be severe enough to where you've been prescribed the device in order to qualify for the 50% rating.
Robert Pike, how long can the same claim be in the realm?
No.
Well, if it's in the realm, then there is no limit. Now, if it's outside the realm, I think it's a 30-day limit.
I don't know. 30 days from what?
Just period. You can't be outside the realm for more than 30 days.
Yeah. I mean, I think it's like the cone of uncertainty is more,
Yeah.
I would actually call it the cone of uncertainty more than I would the realm. I mean, realm seems like, you're going to get out of it at some point.
The realm is like the spot between heaven and hell. The Elysian fields. Robert, I'm just poking fun at you. I don't know what the realm is, but if you mean in the claims process, um, it, we have claims going back 20 years routinely. Okay. Your claim, there is no time limit. All right. As long as when you file the claim and get a decision, you appeal it within a year. And if they still don't grant what you're wanting, you appeal that and you keep the issue on appeal. Now, eventually, you're going to come to the end of the appellate road, and you're going to get it in either up or down vote. Okay. And if it's down and you have nowhere else to appeal, you might be at the end of the road. That could take 3 or 4 years in some cases and 30 in others. Okay. I mean, if your case goes to the Board of Veterans Appeals, they remand it back to the regional office, and you end up going back to the Board of Veterans Appeals, and they deny it, and you go to the Court of Appeals for federal claims, and they remand it, and then the board gets it again, and they remand. It can go back. There's no limit there. That's probably the realm that you're referring to. But yeah, no limit. But there is a limit at the end of the appellate road. Most people never get to the end of that appellate road because they get a Board of Veterans Appeals decision and they don't go into federal court, or they get a decision from the RO and they don't go to the Board of Veterans Appeals. And that's what ends most cases. But if you keep it going in the right way, depending on what happens to it in those higher appellate levels, there's no limit.
All right. Foxtrot, Yankee, Papa, Delta. My friend lost his aunt and uncle while in service, led to depression, led to getting assaulted by soldiers, diagnosed with depression and PTSD. Does he qualify for benefits? Was your friend in service when your friend who was in service, his aunt and uncle were in service, or he was in service? If he was in service and lost his aunt and uncle, and because of that loss, it led to depression, I don't know if he qualifies for benefits, but he should certainly apply for them and see what VA says. That way he knows kind of where, what he's looking at. I mean, we do see clients that come in that, while nothing happened from the military, they weren't in combat or something, but sometimes a child dies or their wife gets hurt or they go through this horrible divorce. And because of those things, it leads to depression and other mental health issues. That counts as long as it manifested during your military service. So you can have it manifest during, or, yeah. So, I mean, I would definitely have them apply for sure. Carrie?
No, I agree completely. One thing I'm not sure what they're saying is it led to depression that led to getting assaulted by soldiers. If you're saying that he was active duty and got assaulted by other soldiers, then that's a claim there for sure. If you got assaulted while on duty in the service, regardless of the aunt and uncle, okay, if you got assaulted and you can show that, then that strengthens the case right there for sure. I mean, I could be reading it wrong, but that was kind of how I took that part of the sentence. I try. Kenny Lamb, I have IMB inclusion body myositis claim at the board. They have asked for another CMP. Very nervous for why. Help.
I'm going to interject. Mr. Lamb, you are our client. We will call you after this. We'll have a call with you, okay? I'll call you as soon as we're off.
Yes, and don't be nervous.
Don't be nervous. Yeah. But I'll take a look into your actual file and see what's going on and know why they're requesting it, and I'll call you.
Michelina Frackleton, I hope I'm pronouncing that right, stationed at Rickenbacker Air Force Base 1976-78, SC to mast cell activation disorder due to toxic exposure. Am I saying that right?
Yeah.
Looking to connect anxiety by secondary by aggravation. How to provide the required baseline for mental health. Good question. So I'm going to assume a few things here. I'm going to assume this this toxic exposure related disease is already service connected, and that you're looking to service connect a mental health problem secondary to that, based on aggravation, meaning you had the mental health problem prior to this other disorder, and it became worse because of this disorder. And you're right, there is a baseline they're going to want to see. If they grant service connection based on aggravation, they're going to want to see what was the baseline, if it can be ascertained, of the disability prior to the aggravation by the service connected condition, and what is it after. And then they're going to subtract those two and compensate you for that. Sometimes it's a roll of the dice. If you have treatment records, obviously you want to give them to VA, or they're going to request them most likely. If they're already part of VA, then they're going to have them already. Usually there have to be exams and they ask the examiners to try to determine the baseline and the aggravation. And so there may be a component of that you don't have any control over to some extent, at least initially. You can fill that void, because there usually is a void there, with all kinds of things, lay statements from yourself, lay statements from other people that knew you. But I mean, really important to look at the treatment records, and it might not give evidence in the type of an exam form, but I mean, nonetheless, you're going to be able to discern someone's general status by treatment records, and then compare that to after the aggravation. That's what the examiners are supposed to do, not always what they do. But that's what I got on that. Arcy, you got anything on it?
I just wanted to say, just for other people, there's not a by secondary by aggravation. It's either secondary or by aggravation when you're claiming these things. So I just wanted to kind of, if you're putting it out there, you can do it by both of those ways. But
I assume that was a typo. But yeah, if it's secondary and it's not aggravation, you don't have to worry about baseline.
Mm-hmm. But yeah, and if your mental health was there, like you had if you had a diagnosis but really no treatment, you were fine, that would be your baseline. Yeah. And then really just things all getting worse from there. A lot of times you can't have a baseline. There's no baseline to be determined. But let's say you had severe mental health issues prior, multiple hospitalizations, things like that, and then you want to aggravate it, they may say, okay, well, now you're at a 70, but you were at a 50, so we're going to give you a 20% mental health rating for that. So it all does depend on what it looks like. Yeah, that's it. Air Force girl, thank you. You're welcome. Don't know what we did, but I'm sure H&P, we're happy to help. The VA used my intent to file date for a claim. I was appealing within the 1 year time frame, so I didn't receive the 1 year back pay for my PACT Act claim. How is that even legal? All right, so with the PACT Act, you had from the time it came out, so August of 2022, you had 1 year to file a claim in order to get the effective date of the PACT Act. If you filed an intent to file within that year, VA should have taken that back to the date of the PACT Act. Correct, Carrie? Because the intent to file counted, right?
It should. I think what you've done here is penetrated VA's intelligence quotient by throwing an intent to file in within a year of the claim that you're appealing, because that's going to confuse them. They can't, when it comes to effective dates, they can't get the simplest of freaking thing right. Okay, so you're appealing something, but in that interim, you submitted an intent to file. Okay, to them, that looks like you're starting a new claim. So I'd have to see what you did. So you had a decision. You submitted an intent to file within a year, but what did you do after the intent to file? And was it within a year of that decision? It should have been. Okay. In fact, you don't need the intent to file in there. All right. If you're appealing something, you got a year to do it. You don't have to do an intent to file. So that right there, to me, I think probably throw VA off. Unless I'm reading that wrong. Ursula, am I?
No, I think you're good.
Yeah. Yeah, I keep things simple with these folks these days. And even that.
We do a whole lot of higher level reviews to effective dates. And literally we just go, hey, this is wrong. The effective date is wrong. This is when I filed my intent to file. This is when I got a claim. This is what the decision said. And I line out the procedural history, and I go higher level review, and I ask for a conference, and I'm like, hey, I don't really need to talk to you, but I've written it all down. Please go read the memo that I wrote about the effective date. And then that is the best way to do it.
Yeah, I see your next statement here. If the HLR denied that, unfortunately, you may have to go to the board, and I would do a direct review. I mean, they're going to have to do it on what's in the record. I would line out exactly what you did and what VA interpreted it as. Okay, and the board's usually pretty good at fixing that stuff.
All right.
My turn, I think, right? Is it your turn?
I mean, you took the last one from me. No, I'm just kidding. You can have this one.
Okay. Nighthawk. How do you get the VA to pay your attorney rather than taking the payment out of your? Wait a minute. How do you get the VA to pay your attorney rather than taking the payment out of your monies? If they're taking it out of your monies, aren't they paying your attorney? Am I reading past it? The VA is not going to pay your attorney for you out of their funds. All right. The contract with your attorney, if you have one, be it a 20% or a 30% or a third, you can go up to a third. Most people don't realize that. That's between you and your attorney, not between your attorney and VA. Okay. VA is not going to pay them directly out of their money. They're going to pay them out of your money. If you have a 20% withholding fee agreement, and if it's at VA, in other words, it's not in the federal court. Federal court's a little different. So yeah, you can't get them to pay unless there's more to your question that I'm not aware of. Now, if they forget to withhold, okay, they're going to pay the attorney, but then they're going to charge you with an overpayment.
Yeah. If you go into a contract with an attorney or an accredited agent, and whatever you come up with, you're going to pay that, whether you're paying that, like VA releases all the money to you and then you pay your agent or attorney, or if there's a withholding contract, VA will pull that amount out of your money, then send you your money and then pay the attorney. But at no point is VA going to pay the attorney's fees or the claims that have done. Those are going to be paid by you. The only time the government will pay for attorney's fees is if you go into the court system and like the BVA gives you a denial, you take it up there. If you fall under certain like financial, then they will pay those attorneys and you don't have to pay anything. You don't get a retro up there. So you just kind of go back down to the regional office. But that's the only time the government's going to pay your attorney's fees is once you get out of the board and up to the CAVC. But once those get granted at the regional office or the board, you're going to have to pay your attorney's fees. So.
And you need to. And I don't say that because I'm working for a law firm. I'm saying that as a veteran. If your attorney's done good work for you and gotten you benefits, as a veteran, as somebody that's considered an honorable individual, my own personal belief as a veteran, live up to your contract.
All right, we're going to do one more question. I know we've gone over, but I didn't give you guys a warning because I was too busy. So let's do one more, and then we'll end it. All right, Benji. Zach Wheat. Wife, 30% hypothyroid, denied for sleep apnea, but set up sleep study and went to CMP afterward. VA sent her a CMP for MTR hypothyroid, but examiner asked about sleep apnea. Does that bode well for sleep apnea? Maybe. I don't know. I don't know what the CMP request did. They may have been looking at all kinds of things. You're just going to have to wait until you either see a copy of the examination or you get the rating decision. So you could definitely request that exam and see what it says. Or if you have an advocate, see if they can pull that for you. So.
Yeah, I'm a little stumped on that one. I'm not sure.
Yeah.
There's too much missing information.
Yeah. All right, everybody. Well, thank you so much for your time. You will see somebody next week, and hope everybody stay safe out there. All right. Bye.
Thanks, everyone.